76, People versus Backus.
Welcome, Mr. Sarando. Welcome to the Court of Appeals.
He always complains he doesn't get us in the Court of Appeals. I'd probably rather be at a Giants game.
Yeah.
Counsel, hold for 1 second.
You'd rather be at a Giants game, right?
Counsel, would you like any rebuttal time?
2 minutes, Your Honor, please. If
2
necess-
minutes. Go ahead.
If necessary.
Proceed.
May it please the Court, my name's John Sarando, and I'm from Syracuse, New York, and I guess since I'm the first attorney here from Syracuse, New York, welcome to Syracuse, New York.
Thank you. Thank you for your hospitality.
We have the, I guess, the fabulous four up on the hill, but in the courthouse we have the magnificent seven, so.
Thank you again.
The,
You can object, Mr. Maxwell, anybody can say.
Judge Piggott, I guess this is the epitome of have gavel, will travel. It doesn't get any better than this. The rule of law that we would seek to come out of this case is that when a defendant pleads guilty to two crimes, one of which is an element of the other, and he receives a legal sentence on each charge, in this case 1 year, which only becomes illegal because of the procedure that was employed, i.e. he was given consecutive terms rather than concurrent terms, which are correct as a matter of law, and he has served that legal term of 1 year, the procedure must be corrected to provide for concurrent sentences. Anything else we submit would violate this Court's rulings in Yaconelli, Kissoff, and to some degree the recent decision in Williams.
So the result here would be he would serve 1 year.
Yes.
That would be the result.
There would be a resentencing proceeding in your view?
No.
No?
No, I think that the appellate court can, on these facts, on this record, can, should have, as a matter of law, indicated that the sentences should be served concurrently.
So they can't remit it? They don't have, I mean, are you saying they don't have to? Or
They don't
can't?
have to.
But they
They
could?
don't have to.
They don't
Yes.
have to?
They could remit it with directions to resentence to concurrent terms.
Right.
But you will not say, yeah, you know what I'm going to ask you. When he does sentence to concurrent terms, can he make one of them a little longer?
No, that would violate Yaconelli. That's just what they did in Yaconelli. The sentence was legal. The fine procedure was illegal. They went back to correct the fine procedure, and the judge says, well, I'm going to give you more time. And the Court of Appeals says, no, you
But
can't
here,
do that.
is this technically distinguishable? Because here you've got an illegal sentence, illegal that it's consecutive, and he says, okay, I'm going to fix the illegal sentence, and while I'm at it, I'm going to double the length.
No, I don't think he can do that under the law.
Why don't the cases of Dickerson or Cameroon control this? Why can't the people ask for the plea to be vacated?
Now we're into a Kisseloff situation where you have the mutual mistake where everybody thought that they could do what they did.
Are you
And they
able-
could.
Are you able to distinguish, I don't know if you're familiar with the cases Judge Graffio is talking about, are you able to distinguish Kisseloff from Dickerson and Cameron?
Kisseloff was the mutual mistake, and that's.
Dickerson and Cameron are a couple of cases that, to the naked eye, look a lot like Kisseloff and seem to come out the other way. I'm just wondering if you have any explanation of why.
Different judges?
That's logic. Don't tell us about logic. Tell us about.
Well, didn't we recently reaffirm in Marrero the Kisloff doctrine?
Yes.
Why is that the better result? Let me ask you that question then, instead of focusing on our past precedent. Why is this the better result?
It's the better result because you have a finite determination that all of the parties thought they could do. It's not a question of the prosecution trying to overreach, the defendant trying to do something improper, the judge trying to throw the book at him, for want of a better phrase. When you have a mutual mistake, and the person goes to jail and serves what we say, what the law says is the legal sentence, then that should be it.
Mr. Maxwell, if I understand his argument, part of it is that this was a negotiated plea on a rather substantial indictment, and that this is not a mistake, that to drive with more than .08 is a crime, and that's the one that goes to the assault. But then there are people who can drive apparently with .08 and not be intoxicated, and your client pled to a sub-3 DWI. So there's driving, there's the assault, which came out of the .08, and then there's a DWI. They're two separate things. Isn't that conceivable, particularly when you negotiate a plea to get the case resolved?
That's not what they did in this case, though. But most importantly, to get to that determination that Mr. Maxwell wants, that i.e. this court says that the sentences are consecutive, that would mean that the DA who did not appeal to this court is now going to get affirmative relief from this court, and he can't get that. So the law of the case is that the sentences are illegal only because of the procedural component that they be served concurrently or consecutively.
So then the question is, what do we do now?
The easiest thing is to say they're concurrent.
You think that's the only thing, really? There's only one remedy here.
On this record,
the concurrent period, whether
yes,
the court does it or sends it back.
whoever does it.
And the end result is your client served 1 year,
He's already served his time in jail, yes.
which is 1 year, correct?
Yes, which is a
Even though he made
legal
a deal
sentence.
for 2.
Pardon me?
He made a deal for 2.
Yes, he made a deal for 2, but there was, now I'm back to, away from policy and back to cases that say that's a mutual mistake. And I think as Judge Backus indicated in his dissent in Laureano, you know, everybody's got to really pay attention to what they're doing, because you never know what's going to happen down the road. And
Well, that's a good rule, but shouldn't we also, to the extent that it's open to us, try to minimize arbitrary results that nobody intended, and even when a mistake is made, if we could avoid this mistake having this kind of unfair consequence, shouldn't we try to do it?
well, first of all, I don't think it's an unfair consequence.
Well,
because-
but you may think one year is a fairer sentence than 2, but he did accept 2. Everybody thought he was getting 2. It's just because everyone made a mistake that he's not getting 2.
But now I'm back to the guy in the defendant in Castleoff who thought he was pleading to felony.
Yeah, okay, but I mean, I guess what you're really telling me is, maybe it would be nice to avoid this mistake having unfair consequences, but you can't do it because you're bound by Kessloff.
Yes. And I think everything else is covered. If there are no further questions, I'll wait for rebuttal.
Okay. Thanks,
Thank you.
Counsel. Counselor, is there only one possible result here, that it's a concurrent sentence period?
No.
Why not?
First of all, I'm not convinced, and I don't think this Court should be convinced that there was a mutual mistake.
If not a mutual mistake, what was it?
It was a plea bargain that was structured in such a way that it is not readily apparent that there's an illegality in the plea.
The appellate division disagreed with you on this.
They did.
Are you allowed to complain about that without taking an appeal?
Yes. The cases cited by my esteemed opponent rely on 470-35-2B of criminal procedure law. I'm relying on 470-35-2A that talks about this Court having the jurisdiction to review and decide in any case where there's a modification, an issue that was determined, and it was a necessary determinative issue at the appellate division.
Well, why not take a cross appeal if you had disagreed with that aspect of the appellate division decision?
Because I didn't think of it in time.
Well, we appreciate the honesty.
See, logic and now honesty, this is too much.
But also because...
Are you asking
But
us...
I have a... I'm sorry, I have a more serious answer as well. And that is that we did not see this as, we saw it as inviting what the appellate division said to do, which is to go back to the court under Farrar, seek a new sentence. And if I could talk about Farrar for just a minute. Farrar has...
Is this how you're distinguishing Kisseloff?
Yes.
So you do intend to ask for vacator?
Well, we have, and I'm not sure if we should, because in my view, under Farrar, where there's a plea bargain, then, and the sentence, oh, I'm sorry, it's not used to this podium. And when there's a sentence that is changed in making it different from that plea bargain, under Farrar, the remedy is that that the DA can object and that can be reopened and can be resentenced. And I think in this case, the better way to put it, and slightly differently than the appellate division phrased it, is that if you do decide it's illegal, which I don't believe you should decide, but if you do decide that it's illegal, then it should go back to Judge Alloy in our county court for determination of what sentence he plans to impose. And if that sentence is less than the 2 years, then the people would have the option to ask that that be vacated. If it's more than the 2 years, then I would imagine the defendant would have the right to say, that violates the agreement that I had.
And how is this consistent with Kisseloff?
I'm saying it's consistent with Farrar.
Are you saying Farrar and Kisseloff are inconsistent?
Well, I'm sorry. I'm getting off point. I think what's happened in this case is that the agreement that was made was not a mistake.
Whether it's off point or not, I would like to find out whether you think that Kisseloff is distinguishable.
I'm not sure. But what I would like you to consider is that to get to these issues, you also have to get to make it fit into, the defense needs to make it fit into the exception to preservation. And under the case law, it has to be readily apparent in the record that the sentence is illegal. And that's not the case because, we've talked about mistake, the judge did not make a mistake in the way he phrased.
Okay, but I understand you can make an argument. You're making an argument the appellate division erred, and you certainly can make an argument that they erred if you're asking us to affirm on alternate grounds. But it sounds to me like if you prevail in this argument, we'd have to give you affirmative relief, and I don't think we can do that, can we?
Well, I think that it's fundamentally part of what they decided in reversing on the law. They had to decide that it's a legal issue that's before them. If it's not preserved and preservation is required, then you can't decide on the law. And thus it falls under 470.35(2)(a). And when Judge Alloy took the plea, he was very careful. It was indicted as that the person drove and it was in violation of subdivisions 2, 3, and 4. But when he took the plea and the defendant admitted to his conduct, he admitted for purposes of vehicular assault that he was driving with .08 or more blood alcohol content. And that plea was accepted, and then he pled to the common law subdivision 3 DWI. And I don't think that was a mistake at all. I think this is an argument for reversing the appellate division and reinstating the judgment appealed from. But we can't do that because you didn't file a notice of appeal. Well, Your Honor, again, I think you could because it's a necessary step to the defendant getting any relief in this case. And it's a necessary component, and thus it underlies and is part of the modification, and it comes under this Court's jurisdiction. And again, if I may go into, if you do decide that the sentence is illegal, the argument that there's a bar on resentencing under your Judge Garfield's decision last month in Williams, I think shows that there's not a double jeopardy bar in this case because the case is still on direct appeal, and there's not a statutory bar to resentencing under 430.10.
So you say that the judge could give him 2 years concurrent and then give him credit for the one he's already served and say, go serve the other one.
He could resentence him to any legal sentence.
Okay.
Beyond 2 years?
The only legal sentences that would be, say he was to receive a state prison sentence, though it would either be 1 year to 1 to 3 or 1 1/3 to 4. So it would be by its definition or by its limitations.
Because you're vacating the plea, so there's no plea agreement anymore for the
Yes.
2 years?
Or even, again, the judge, I would think the proper procedure would be for the judge to indicate what the judge intends to sentence, and then the parties deciding whether they want to move against the plea.
But even if you lose on even if we were to hold that under Kisloff, the judge can't permit, at least can't permit you, maybe he can permit him, but he can't permit you to withdraw from the plea agreement. The judge, you say, the judge still can say, basically can sentence him to more time than he originally got.
Yes, Your Honor. He could sentence him to more time, and it would be that the defendants, I would imagine the defendant would then have to give him the option to withdraw the plea, and after a trial, again, if he was found guilty, to receive whatever sentence the judge felt was appropriate. If he's not found guilty, not sentenced. So that, I think, would be a refinement of Farrar, but consistent with Farrar, and a proper way to resolve the case. The defendant should not be given this windfall of a 50% reduction of his sentence. If he had felt at the time that he was entering into this agreement that it was illegal, he could have said so. On its face, it is not an illegal sentence the way the plea was taken, and I'd ask you to not give the defendant that relief.
Okay. Thank you, Counsel. Counsel Urbano?
He's taken a completely different position today than he took in the appellate division. In the appellate division, his position was, if this doesn't go through, we want a Farrar situation, and we want this guy to go to state prison. And that's been their position ever since this appeal has started. So to now say, well, let's see what the judge is going to do, I think is somewhat disingenuous. They want to put him in state prison after he's already served a legal sentence, and we submit under Kisloff that's improper. And as far as withdrawal goes, we don't seek that it be withdrawn. And I think it's clear that there was a mutual mistake, as they indicated the last time we were in court. You're driving down you're trying to parse this out, this driving while intoxicated, a little too much. And we submit that I'm sure the court will see that it really is an illegal sentence, and they didn't appeal. Thank you.
Okay. Thank you both.